Well, with regard to sovereignty and world order, the title, there are two questions that arise at once. One is the question that I'm sure is on everyone's mind at the moment, the question of intervention, forcible intervention in violation of sovereign rights, and the question is, when is it justified? And the other question is has to do with ceding sovereignty to the international community. So when is that appropriate? And when is refusal to do so justified? These two issues, which interrelate, have a long history. They took a decisive turn about 50 years ago at the end of the Second World War, when a new international regime was established, primarily under U.S. initiative, a reflection of overwhelming U.S. power that had been nothing like it in history. That new regime had a number of components. There was a human rights regime articulated in the Universal Declaration, an international political order, which is the one I mainly want to talk about, articulated in the UN Charter, and an international economic order developed at the Bretton Woods Conference, sometimes called the Bretton Woods System. These three were related, closely interrelated. It's maybe less known, though it should be known, in the case of the Bretton Woods system, but a primary element of it was motivated by concerns over sovereignty and human rights, over the other two issues. The Bretton Woods system was based, as I'm sure you know, on regulation of capital. A large part of the reason for that was the understanding of the framers of Bretton Woods that capital mobility is a weapon, a powerful weapon, in fact, against sovereignty, hence against democracy to the extent that the polity is democratic, and also against human rights, specifically against the socioeconomic rights that are a core element of the Universal Declaration, and that were particularly significant because of the situation at the end of the Second World War, when they were very strongly supported. The idea is, the point is more or less obvious, explicit in Bretton Woods planning, and discussed reasonably well in standard economic histories. So Barry Eichengreen, in a recent history of the international economic system, points out succinctly the main point. He says, as many others have pointed out as well, that by gross measures, the level of globalization today is more or less like what it was before the First World War. It's returning something like the pre-World War I level, but with crucial differences. And the crucial difference that he emphasizes, this is in history of the international financial system, the crucial difference that he stresses is that at that time, pre-World War I, it's mostly quotes, economic policy making had not yet been politicized by universal male suffrage and the rise of trade unionism and parliamentary labor parties. In other words, there wasn't much in the way of democracy. So therefore, the costs of financial rectitude, meaning making sure that investors and creditors are happy, those costs could be transferred to the general population, who didn't have much of a voice. But by World War II, things had changed. There had been an expansion of democracy, and there was a new and strong focus on human rights. As a result, he says, the Bretton Woods system imposed limits on capital mobility as a substitute for limits on democracy, as a source of insulation from market pressures. Again, market pressures is that code word I already described. There's, of course, I think, a fair assessment of the thinking and what happened, but it does have a corollary. The corollary is that the dismantling of the Bretton Woods system since the early 1970s, you would expect it to be, and indeed it has been, accompanied by a strong assault against functioning democracy apart from forms, and sovereignty, that is, popular sovereignty, and also against human rights, specifically against the socioeconomic provisions of the Universal Declaration. In fact, that's a good part of the history of the past 25 years. And looking at it closely shows the interrelations of these things. Well, there's a lot to say about that, but come back to it if you like. But I'll drop that topic, though it's a crucial and central one, and has rather interesting things have happened just in the last couple of weeks relating to it in countries as different as Germany and Brazil. But I'll put it aside and turn to a narrower question, the question of the international political order. And again, the two issues of sovereignty. So what about the right of intervention, which violates sovereignty, and what about the willingness to relinquish sovereignty, that is, to take part in an international community, to submit to an international regime of world order? There is a truism, which I won't waste much time on, unless the most powerful are willing to accept the rules of world order, that is, to subordinate a degree of sovereignty to international law and international order. Unless that's true, the system is plainly a farce. It's nothing more than a weapon to use against the weak. That ought to be a truism. Now, these two issues, these two aspects of the question of sovereignty and world order, they are related. They're the simplest way to perceive a relationship is to recognize another truism, namely, insofar as intervention violating sovereignty might be legitimate, the judgment that it is based on judgments of good faith on the part of those who are intervening to violate sovereignty. And a crucial element of good faith, crucial evidence for it, is precisely the willingness to accept the rules of world order yourself. That is, to relinquish sovereignty under the regime of international law and international order. So the 2 points are quite closely related, just on essentially logical grounds. Well, that much is obvious, and it's also familiar. So take, say, the most recent extensive scholarly study of humanitarian intervention, which is a kind of a hot topic in the last couple of years. This is a book came out a year or two ago by Sean Murphy, who's now the counselor for legal affairs in the U.S. Embassy in The Hague. And he looks at both the legal and historical aspects of humanitarian intervention. It's actually a PhD thesis turned into a book, so very scholarly. In the period right before the New World Order, that is right before the UN Charter, so in particular the period in between the Kellogg-Briand Pact of 1928, which banned the use of force, and the UN Charter, which spelled that out much more explicitly. In that period, he points out that there were examples of what was put forth as humanitarian intervention. He finds 3 major examples of states that articulated the right of humanitarian intervention. One was Japan and Manchuria, the second was Italy in Ethiopia, and the third was Germany in Czechoslovakia. Well, no need to comment much about it. They all, if you look at the declarations and pronouncements, presumably as sincere as anyone else's, they just exude humanitarian rhetoric, and they're full of talk about self-defense, so quite impressive. As I say, there's no need to comment about the examples, though we might ask how they compare with the post-UN Charter interventions. That's a fair question. Don't advise you to write a thesis on it, but it is a fair question, and it has interesting answers when you pursue it. If you want my opinion, I've written about some of the cases comparing them. Well, that brings out the obvious fact that unless there is good faith as illustrated by a willingness to accept the rules of world order, you can't take very seriously any claims about humanitarian intervention, even when they have a degree of force, as in fact, if you look, as in the case of all propaganda, they did in these cases. Well, let's take a more recent case, very recent, Bosnia. During the period of the worst atrocities in Bosnia a couple of years ago, no one was willing to intervene by force. And that reluctance elicited very strong criticism, huge torrent of criticism. However, there was one fact that was kind of generally more or less overlooked or not mentioned at all. Namely, it seemed that there was one country that was willing to intervene to protect the Bosnians from the slaughter that was going on, and it might well have been able to do so, namely Iran. Well, that could have been feasible. Maybe the U.S. could have provided them some logistic help, a couple of C-130s or something. But we don't. That was not an option. I mean, nobody considered that possibility. If anybody had bothered to mention it, it would have been ridiculed. In fact, Iranian support for Bosnia, supply of arms, advisors, volunteers, that when it was detected, that was considered a very serious charge against Bosnia and against Iran. And we have to ask why. Well, one obvious answer is there's no presumption of good faith. Fair enough. I don't presume it either. But there is an obvious question. Is Iran's record on intervention, how does Iran's record on intervention compare with those who did intervene, say with the United States? Well, fair question, not asked. But these questions are plainly worth asking, and everywhere you look, those questions arise. Well, they're not asked. In fact, they're unthinkable. When they are mentioned, they tend to elicit tantrums. For example, on the part of one of the leading academic specialists on humanitarian intervention, Thomas Weiss, his reaction to this question is that it's just sound bites and invectives about Washington's historically evil foreign policy, so we can therefore forget about the question. Or we can turn to Henry Kissinger, who explains why there's no issue. Writing a couple of weeks ago, he points out that the Balkan conflicts over many centuries are fought with such unparalleled ferocity because the people there lack Western concepts of tolerance. So there's plainly no issue about Western intervention because no question of good faith in the light of the history of Europe internally, where people, French and British and Germans, treated each other with such loving solicitude over many centuries and acted the same way in the rest of the world instead of showing the unparalleled ferocity that you find in these savage areas. Well, given that history, there's no question of good faith that arises if the West intervenes in the Balkans, so we can get rid of the question that way. Well, if we decide to be serious about the issues, departing from convention, then a lot of questions arise. So we might look at some of the cases that might qualify as humanitarian intervention. Good place to start. Maybe the most obvious is the Vietnamese invasion of Cambodia, 1979, which terminated the Pol Pot atrocities, which happened to be peaking right at that time. The worst atrocities were it's now known, were in 78, probably late 78, just at the time of the intervention, which was in December 78, and that terminated them. Well, what was the reaction to the Vietnamese intervention to terminate the Pol Pot slaughters as they were peaking? The reaction was bitter condemnation of what the New York Times called the Prussians of Asia. There was an immediate Chinese invasion to teach them a lesson, which the U.S. strongly supported. The United States recognized democratic Kampuchea at the United Nations officially because of its continuity, that was the word that was used, because of its continuity with the Khmer Rouge regime. The U.S. also gave military aid right away to Pol Pot, a little bit indirectly, but not very subtly. Vietnam was severely punished for this crime. Harsh sanctions were imposed. That was for the crime of ousting Pol Pot and terminating his massacres, invading in violation of international law, which bars the use of force in international affairs except in self-defense, as was grandly proclaimed. In fact, this is one of the few cases, maybe the only hard to think of another one, maybe the best case, if not the only case, where a self-defense justification for intervention was actually warranted. The Khmer Rouge, Cambodia, was carrying out murderous attacks in Vietnam along the border. So maybe you could justify it, maybe not. But in any event, that was certainly not the reaction. Well, that's probably the clearest case in the post-war period of an post-Second World War period of an intervention in self-defense, plausibly in self-defense, and with humanitarian consequences, in fact, very important humanitarian consequences, if not humanitarian intent. And it's kind of interesting to investigate the reaction. What happened in response to this? Well, if you want to be serious about the question of humanitarian intervention and how it's understood in the West, that's another good example to look at. Well, every such example, this one or any other one, has to be looked at closely. I mean, you have to look at it carefully. A few phrases don't suffice. But all of these do raise obvious questions. They raise questions about the legitimacy of humanitarian intervention, about the question of good faith, about the record of those who are exercising the use of force. In particular, they raise questions about their record in accepting an international regime of world order and therefore ceding sovereignty. Just as in the case of intervention, they are compelling someone to cede sovereignty. Because ceding sovereignty is what it means to participate in a community, no matter what it is, whether it's a family or international affairs. Participation in a community involves ceding a degree of what we call sovereignty in international affairs. Well, the regime of international order is pretty clear as these things go. The UN Charter strictly bans the threat or use of force, except in explicit circumstances. If explicitly ordered by the Security Council after the Security Council has determined that all peaceful means have failed, or under the famous Article 51, which permits self-defense against armed attack until the Security Council acts. Armed attack is a narrow notion in international law. Well, the Charter isn't an axiom system for arithmetic, so the rules are not entirely precise, although they're reasonably clear. And they're also not moral absolutes. That is, they're not inviolable. You can imagine circumstances in which maybe they should be violated. But there is a burden of proof. How heavy the burden of proof is on anyone who violates them. How heavy that burden of proof is a value judgment. So, for example, if you think it was fine for, say, Saddam Hussein to invade Kuwait, there's no burden of proof. On the other hand, if you think there was something wrong with that, then there is a burden of proof on any move to use force in violation of the Charter and reasonable principles. Well, beyond that, there's at least a tension, if not an outright contradiction, between the Charter and another one of the pillars of world order, namely the Universal Declaration. And it's that tension that opens up the question of humanitarian intervention. There are opinions about this by distinguished authorities who've expressed strong views on the matter. One, the most important one, is the International Court of Justice. In the case of Nicaragua versus the United States, the court took up this issue. The U.S. had not claimed the right of humanitarian intervention, but the court discussed it anyway and ruled strongly on the matter, saying there is no such right. Specifically, the court ruled on a question that was indeed applicable, the question of humanitarian aid, and it gave an explicit, unambiguous determination that all U.S. aid to the Contras is military aid, including Band-Aids. None of it qualifies as humanitarian judgment of the court. Well, that decision was dismissed. In fact, I don't even think it was ever reported. The military aid was called humanitarian aid. It was called that to the end until the U.S. had won that war. In fact, the court decision altogether was dismissed.